Michigan Supreme Court has overturned the conviction of a man found guilty of fleeing from Kalamazoo Department of Public Safety officers and resisting arrest.
The ruling is having an impact on how Michigan officers articulate reasonable suspicion. News 8's Amanda Porter has been looking at this ruling. At 6, she'll have more on its implications for both the police and the public.
But first tonight, she's looking at how the case came about. Amanda?
The People v. Michigan v. Douglas Prude case came down to the Fourth Amendment. More specifically, what is reasonable suspicion on the part of police, and when does that suspicion violate a person's rights? This Supreme Court ruling could impact you or someone you know who may be in the wrong place at the wrong time.
Douglas Prude was just visiting his girlfriend at the Fox Ridge apartment complex in Kalamazoo back on May 30th in 2019 when suddenly he became the subject of a police investigation. 2 officers on patrol tried to detain him to verify if he was trespassing on the property, but Prude drove away. He was later arrested and charged with fleeing and eluding and resisting arrest.
There was no reason to suspect Mr. Prude of any wrongdoing, and so they had no right to detain him, and so it was not unlawful for him to drive away because the police orders themselves were unlawful.
John Zevelking is the attorney who represented Prude in his case. For years, lower courts upheld the arrest, ruling officers had reasonable suspicion to detain Prude. The case would eventually end up on the Michigan Supreme Court docket.
Yes, it's difficult to get into the Michigan Supreme Court. They don't take a lot of cases. And then it's difficult to get a positive ruling because the courts always have some deference for the courts below. But in this case, we just felt it was worth going all the way.
Earlier this month, the state's high court ruled in Prude's favor.
The Michigan Supreme Court ruled is simply being in a high crime area is not a reason to detain someone. And just one thing about high crime areas, you or I don't know where those are necessarily. That's a police designation where they do a lot of proactive policing there, and I would call it over-policing of those areas.
Crime has been an issue at Fox Ridge apartments in recent years, including homicides and shootings. Kalamazoo Public Safety Department's police chief, David Boyson, told me their officers often patrol the complex to help decrease violence.
We do our best to do that, like in this case. The courts disagreed with that, and we're going to learn from it, but those officers weren't there to bother, harass an individual. They're there to try to protect the community. And the person may have said that they were visiting someone. We had no proof of that. We don't know if he's telling us the truth. They just wanted a little time to investigate that because we do have, unfortunately, high incidents of gun violence in that particular apartment complexes, which one of those reasons those officers were there.
Boyson was not KDPS chief when Prude was arrested, but supports his officers' actions.
The detention was based on what the officers believed was reasonable suspicion. So an officer, Terry versus Ohio, if we believe a crime is afoot, we have reasonable, and we can articulate reasonable suspicion that crime is afoot. We don't have to prove that they committed a crime. We don't say they're guilty, but we just can take the time to investigate whether a crime is actually committed.
Zevelking says KDPS officers had no evidence of trespassing, and failure to give a name was not enough to create reasonable suspicion. Court documents obtained by News 8 show 2 KDPS officers tried to detain Prude while they checked the apartment's database for trespassers. The complex has a visitors policy that, if violated, could lead to arrest. But those court records also show neither officer had seen the apartment complex policy they were trying to enforce.
The United States Constitution protects against unreasonable search and seizures in the Fourth Amendment, and that includes being detained.
Part of my argument and part of Mr. Prude's argument in the case was that some arrangement with an apartment complex can't be a basis for a reasonable suspicion. It has to be legally a reasonable thing that's happening here. Simply being there does not give the police the right to come up and stop you, detain you. You can't leave until I investigate you. You can't do that. And then further, they ruled that you don't have to be fully cooperative just because you're in a high crime area.
And the state Supreme Court agreed. ruling there were not enough factors proving officers had reasonable suspicion to detain Prude.
Many court rulings say you need at least come up with at least 5 factors. I call it the rule of 5. And if the officers can list 5 factors on why they believe that crime could possibly be afoot, you have met the reasonable suspicion standard. We actually try to say 7 is even better. I think the officers probably had enough factors, but could have maybe articulated it better, and that's where the training comes in, is taking the time really to articulate those factors in your report, and that's critical.
Civil rights attorneys tell me it's important to know your rights when behind the wheel dealing with police.
So he knew them very well, and he understood the situation. That's kind of unusual. You know, most of us don't have that in our back pocket, exactly when the police can detain us and when they cannot.
So what do you need to know if you end up in a similar situation? I'll have that part of the story at 6.